Okay, so just to start, a quick introduction. And is it all right if this conversation is recorded?
Javier Pan?
Is it all right if this conversation is recorded?
Okay.
Okay, is that all right? All right.
No
So
problem.
just an introduction. So it's from what I can see, you're a very experienced and esteemed jurist in some of these investor-state dispute cases, and I can see that you've been in over 200 arbitrational proceedings worldwide, and of course have done a lot of work in that. So I'm wondering if you could then maybe talk just very briefly about some of uh, how it is that you got into this business.
Well, as a matter of fact, I've got my PhD in Germany, and then I went back to Spain. I've got my university professor title, and then I was asked by the ICC to chair an arbitration tribunal in Vienna, in which, I happened to use for the first time lex mercatoria in our award, and that was the famous case Norsolor. And after being this case through the Supreme Court of Austria and La Cour de Cassation in France ratifying what we said, they started to appoint me as an arbitrator, commercial arbitrator. And then the World Bank, the president of the World Bank appointed me in the panel of arbitrators of the World Bank. And, I started some 30 years ago with Letco Liberia. And then I was appointed by the Kingdom of Spain to be a member of that panel of the ICSID, and that's the way I was involved in different arbitrations.
Okay, thank you. And so, in general, how do your clients go about, how do clients in general go about finding an arbitrator that's right for them?
Well, when you speak about clients, you have to distinguish, because I act in both capacities, as a general counsel, as a counsel, and as an arbitrator. As a counsel, we try to find the best arbitrator we could have for the dispute, and that's the reason why we have to make an evaluation within the names possible to be appointed, who is the best and most appropriate person. As an arbitrator, I am appointed, and normally the parties look after some arbitrators, and I am on the list of those parties and all the institutions to appoint the loan chairman or the chairman of the arbitration tribunal, and that's up to the institution to appoint me.
Okay, great. So, of course, for the work that I'm looking at, I'm particularly interested in, as you mentioned before, the World Bank and the International Center for Settlement and Investment of Disputes. So, could you maybe talk a little bit about the relationship when you're proceeding to go through these meetings? Do you think it's a consensus-based feeling, or can it be really frustrating, or do you think it varies very much from case to case that's been brought to this tribunal?
Well, it depends. It depends from case to case, but the appointment of especially the chairman of the arbitration tribunal, it's by consensus of the parties. I don't think the ICSID will appoint someone without getting the consensus of the parties.
Certainly. Okay. So I guess I'm going to go ahead and skip down to some of the more, so that was just some general questions, because I think people are kind of interested in, like, it's kind of a foreign thing, it's a very specific thing, but as you probably know, it's a very controversial thing being discussed in some of these major mega agreements between the United States and Europe, and also the TPP members. So recently the USTR, they put out this statement talking about this fact statement discussing some of the issues which people talk about. Is this a breach of sovereignty and so on? So I'm wondering, the first and foremost is in some of the classical agreements in which the U.S. is engaging some of these investor-state dispute tribunals. How would you address someone who says, okay, well, I think that this is a breach of our sovereignty and we don't like this?
Well, as you know, the history of the whole thing is that some years ago, not very many, when an investor had a problem, had to go to the diplomatic protection of his own country. In the 1965, it was agreed, the Washington Convention, and the Washington Convention was exactly the purpose of avoiding diplomatic protection and entitling the investor to start arbitration against the host country if there is any breach of a treaty. And, well, that was a big movement ahead in the international security in the flow of capitals and technologies in the world. And, well, afterwards, the whole thing was complemented by the bilateral or multilateral investment treaties, and that was the reason why the whole system exploded and has been used now on a massive way around the world. I mean, of course, the idea of the founders of the exit in '65 was to give, well, a forum of arbitration to solve the disputes, and that started that way. In principle, at the beginning, it was just for natural resources, but afterwards the arbitration tribunals said that investment should not be confined just for natural resources, but it was the expansion of the concept of investment for that purpose. Nowadays, of course, there are some complaints, especially from the losers of those arbitrations, who are not satisfied the way they say it's done. But anyhow, the big majority of cases are decided, and the business disputes are settled in a very satisfactory way. And that's the reason why I think there is much more of intellectual discussion on that issue more than a practical. I mean, I think the system created by the Convention of '65 is working very well. The only thing is that some cases have to be taken into consideration. And as you said, I mean, now discussing the big agreement, the big treaty between the U.S. and the European Union, well, there is a big discussion about introducing or not this system. But anyhow, there are more than 3,000 bilateral investment treaties who are operating nowadays, so I don't see any real political discussion on that. I mean, it's more political than factual. I mean, the fact is working very well, and probably, I mean, politicians, they like to create big problems where in practice there are not so many.
That's a very interesting point you made. A little bit about some of the other research I was doing. I had the opportunity to go to Mexico and study in university down there for a semester, and I actually managed to talk with one of the gentlemen who was a part of the negotiating delegation from the Mexican side of NAFTA. And he also said that a lot of this stuff is that you have, of course, it's very political, and they're not when the actual factual basis of these cases seems to be, as you said, working quite well. So when you address, for example, there's one thing that was really controversial during NAFTA, which was called like this a regulatory chill, and where states would be afraid to enact legislation to protect consumers. And one of them, which has recently come up, is, for example, regulating tobacco in certain Southeast Asian countries where there almost is no health regulation. And some of the people, they're saying, okay, well, we can't do this. And I believe it was Indonesia now that's wanting to cancel all its investor-state dispute settlement, or all its treaties that have that in there. Would you be able to comment on that, both the legal side and then maybe the political side of that?
Well, I think one is the political aspect, and the other one is the practical aspect of disputes. And, well, from the political point of view, you will see many people talking things they don't know about. I mean, I'm convinced that the people who drafted, for instance, the Lisbon Treaty for the European Union, they didn't know what they were talking about, and that's the reason why now the regulation of investment disputes in the European Union is a real chaos, because they introduce modifications in the Lisbon Treaty without knowing what it is. If you listen to some members of the Parliament, the European Parliament, talking about those issues, you will see that probably they are very far away from reality. And, well, of course, some countries, they feel like blaming those arbitration tribunals for the results they have. And one case is the Indonesian case, after some, well, experiences they had, or for political reasons in Latin America, some countries. But anyhow, that's not, let's say, the communist opinion of everybody. It's, well, some problems arising out of this circumstance. Of course, I can imagine that the sovereign states who have signed those agreements, they might consider that sovereignty issues might arise out of that. But I mean, it's not really a very substantial issue, in the sense that they sign on a sovereign basis those treaties, and in the basis of those treaties, those tribunals are working.
Okay, well, I think that's a very good answer, and that also corresponds mostly to my research. So my next thing is then talking a little bit about, I guess, the transparency complaint. As I've been doing my reading, just downloading documents from the World Bank website, when I'm reading them, the reports and the findings, they seem to be quite reasonable. But when you read the positions of other lawyers and so on, there are obviously some complaints. So I'm wondering, for the public to have access to this, do you think that those publications that are directly available from the World Bank are giving enough detailed information about the pretenses and the facts, and is that satisfactory in your opinion?
I think investment arbitration, especially within the World Bank, is a very transparent system of solving disputes. I mean, there are very few tribunals in the world in which everything is published in the website of the bank. The following day, those decisions have been taken. I mean, I've got the impression that transparency is not an issue in those international business disputes. Probably the transparency might be an issue in international commercial arbitration, but not in investment protection arbitration.
Okay. All right. Well, I think that sounds good. So I guess now to go to maybe some more specific cases maybe you were involved in. I read there was one case you were involved in, correct me if I'm wrong, waste management industries versus the United Mexican States. Do you recall, was that something you were in that case? Was that something you were involved with?
Yes, I do.
So like some of the people, like there was one document talking about double dipping, and of course there was some resistance in general, as there was also another case called ironclad or metalclad, which was also quite controversial. Could you maybe comment on some of so your experiences while being in this this tribunal, how the interactions were, and then versus what was happening outside of the actual tribunal?
Well, the doctrine has always the right to criticize everything, and I'm very happy about that. That's part of the transparency. So when you issue an award or you issue a decision, I mean, it's published, and when it's published, everybody has the right to criticize, and And probably the waste management case you are talking about was a case in which we, the tribunal, we decided we had no jurisdiction due to the fact that there was pending arbitration on the domestic arena. And normally they blame the arbitrators because they say that they want to attract jurisdiction in any case in order to be competent and to deliver the award afterwards. But that was a case in which we honestly decided that we thought it was the moment to say no to the jurisdictional issues of the case.
Okay, so that is a very specific case where you think that you where the tribunal exercised restraint and in terms of not expanding its jurisdiction. So I thank you very much for that answer. I think another question I'd be interested in is a general going back to the jurisdiction of the tribunal. So you feel that these considerations, or jurisdiction, I guess that's the wrong word. Do you think there's a culture because in terms of having a sort of say a case law kind of procedure? So, for example, do you take into account other cases from the past? It's my understanding that you're not bound by sort of say the legal, I guess, proceedings of other cases. Could you maybe talk about why that is and whether that's an issue or not?
Well, take into consideration that what we have done in the last 15 years was a real revolution within the international business law. You cannot imagine that some years ago that someone was entitled to start legal action against states. The idea of having international arbitration on the basis of public offer done by a state in a international public law treaty. It's really amazing the advance we have done in those 15 years. There is no difference now very clear between public and private international law. There is no, as the tradition said, that only the states were the subjects of international law. Nowadays, anyone is entitled to promote an arbitration against a sovereign state. And, well, of course, in those 15 years or 20 years, we are working on this explosion of business arbitration. We have created, I think, somehow a consistent case law in many matters of international arbitration. And that's something very important because sometimes people try to blame this horizontal concept of international law against the vertical consideration of international law having the ICJ at the top of the vertical system. Some people say, well, there is no way of creating this clarity within the arbitration awards, and I can guarantee you that there is really consistent case law, and even if we are not bound by any previous decision, we take into consideration that doctrine, what we know, because we have created it. It's really very interesting to say that nowadays there is a consistent case law, and what it was a problem after and before, in order to find the opinio juris in the customary international law, now this customary international law is proven and has the opinio juris through those consistent case law we have awarded in our arbitration. So you cannot take into consideration with traditional criteria the phenomenon of international investment arbitration. Is something very new, but at the same time, being new system of settling disputes, it's something that it has created a consistent case law.
Okay, that's very interesting. So, and I'm also, of course, happy to hear that because, again, one of the things I think a lot of people have issues with is that they're kind of drowned in all the different opinions and informations and not looking at some of the more concrete examples. So I guess another question that, and I think this will be one of the last ones that I'll ask you is when the World Bank is sort of say considered to have a dubious reputation, especially among some of the developing countries and some of the requirements that they've set, and there are a lot of people saying, okay, well this is a push for some neoliberal ideas, and the World Bank in itself isn't accountable to anybody. How would you address someone who states that they feel that these arbitrations are not do not have a democratic interest in and are not accountable to
well, the answer to that is I don't care about the World Bank being accountable or not. What I do care is about the international arbitration system being accountable, and for that I think it's really a true situation in which all over the world now there are arbitration tribunals deciding cases, and at the end the parties choose the arbitrators and they are responsible for them. And in the sense that once they have appointed some arbitrators, well, they leave in the hands of the arbitrators to decide. I mean, you say, well, it's democratic system. I mean, I think the states sign bilateral investment treaties. The states, they sign multilateral treaties. The way they do is because they are sovereigns. And the ones who sign are the ones who have been elected in their countries. So at the end, there is no lack of legitimacy in the system, in the sense that the one who were elected in their own countries appointed the government signed the treaty. So I think it's that's the way to make it from the democratic point of view legitimate.
Okay, so that's very interesting. So in fact, what you're stressing is that it's the responsibility of the states and the other participants in a tribunal to make sure that they pick the tribunal that they want, and they pick the arbitrators they feel are best able to represent them.
That's correct.
Yeah. Okay. Well, that's an interesting perspective, which a lot of the people that I've been reading about they don't take very much into consideration, which I think is interesting. So I think the last question on some of these more technical things are the United Nations Conference on Trade and Development. They issued a report recently that talked about how this in the recent years these tribunals have been expanding and have been there's been an increased volume. Do you think that they'll become sort of an international standard that saying, okay, is this going to be the World Bank that is going to take all these, or do you think that you'll kind of have a free market approach that the different countries will kind of figure out their own arbitrations, or do you think there needs to be a more systematic and overall regulation then on figuring out how to
Well, you speak only about the World Bank, but nowadays there are other investment arbitration, other institutions taking care about the investment arbitration. I mean, if you see the PCA in The Hague is doing administering many arbitration tribunals. And what is really very important nowadays is the ad hoc system of international tribunals. I mean, those cases, they don't relate to the World Bank. And when someone, for political reasons, they have any reluctance to go to the World Bank, they could use other institutions, or they just could go to the ad hoc system. So, I mean, it's not fair to generalize all these political complaints that some countries have against the World Bank to the arbitration institution itself, because, I mean, the World Bank is administering one part of these arbitrations through the ICSID, but not all of them.
Okay. I'm going to quote very briefly then another quote from this UN paper that was published. It says, arbitrational decisions, problems and inconsistencies, and erroneous decisions. Those arbitrational decisions that have been entered into the public domain have exposed recurring episodes of inconsistent findings. And then it goes on to expand on that. So this inconsistency issue, do you think that how would you address that?
Well, you cannot generalize. I mean, like always, you can find decisions you don't agree or you think they are inconsistent, but I mean, in most of the cases, there is a consistent case law created by those decisions. The only thing is that sometimes, they say, well, I don't like that kind or that decision, that concrete decision. Okay, I mean, in the World Bank, you can go through the exit to the annulment proceedings and try to get it redone if there is reason for annulment. But I don't think it's fair just to generalize and to say that the arbitration system gives, as a consequence, inconsistent decisions. I mean, the process of decision-making process could be consistent or inconsistent depending on the decision-making process of the arbitration tribunal, but you cannot generalize.
Okay, that's very interesting. So I have two more questions left. So I guess, and to sum up what we've said now, your basic opinion on it is that the system that we have, and focusing on the one that's a part of the World Bank, is a good system that seems to work and address the needs, and it is the responsibility of the states to choose which tribunals they want to use and choose representatives that they feel can.
No, first the states have to either to modify or to introduce new treaties, because at the end the whole thing is based on treaties. If they don't agree with the treaties, they should denounce or modify them. And then second, they should work in the institutions, because at the end PCA or exit are governed by the states. So I don't think they can complain afterwards that it doesn't work if they don't really go into the actual administration of those institutions.
Okay. All right. So second to last question. Could you name 3 cases that were the most significant in, for the investment state dispute tribunals, so to say, affirming their effectiveness and which you think are the most groundbreaking?
Well, for me, there are 3 in which I was involved. First is Lanco against Argentina, because it was the starting point of BIT being the basis for arbitration. Second, Salini against the Kingdom of Morocco, in which we define the concept of investment, and then Lucchetti against Peru, because we went into the question of corruption and the impact of corruption in the investment arbitration. So I think those 3 cases probably for me were the most important cases in which I've been involved.
All right, that's very interesting. I'll go look at those some more. So, and my final question for is something a little again up to your opinion. For you, what is the most memorable experience of your time dealing with these things, or maybe were there some really abnormal or crazy situations that you could think back on, which people of the public would maybe not be aware of?
I don't catch your point.
The point is if you feel that there's some if there's a particular memorable situation in your proceedings. It's a very broad question, just saying if you felt there's something that you felt very strongly about in these proceedings.
Well, what I feel very strong is about the necessity of transparency in those cases. And in the moment in which there is transparency, I mean, you are cross-examined by everybody in the public opinion. So, I mean that's the important part of being transparent. That everybody, especially the taxpayer, has to know why this settlement system is organized and is working.
Okay, well, I think I'm satisfied with that answer for sure. All right, well, I think do you maybe have any other comments that you'd like to make? Because otherwise,
no, that's it. I think that was a good cross-examination.
I think so. Okay, we're at 31 minutes. I have to say thank you very, very, very much for talking with me. I'm also speaking on behalf of some other students that are sitting here in the room with me and have eagerly been listening. So we're really, really happy that you were here and willing to talk to us about some of these issues.
Well, I'm very, very happy to cooperate with your activity as a student.
Thank you very much. Have a good day, sir.
Same to you. Bye. Thank you.